This podcast is brought to you by Progressive. Are you driving your car or doing laundry right now? Podcasts go best when they're bundled with another activity, like Progressive home and auto policies. They're best when bundled too. Having these two policies together makes insurance easier and could help you save. Customers who save by switching their home and car insurance to Progressive save nearly $800 on average. Quote a home and car bundle today at Progressive.com. Progressive Casualty Insurance Company and Affiliates. National average 12-month savings of $793 by new customers surveyed who saved with Progressive between June 2021 and May 2022. Potential savings will vary.
Hey Slate listeners, I'm Christina Cauterucci, the host of Slow Burn, Gaze Against Briggs. I want to tell you about a special event we're doing at the Tribeca Film Festival in New York City on June 13th. To celebrate the new season of Slow Burn and Pride Month, we'll be hosting an exclusive taping of the show with special guests including Eric Marcus, the host of Making Gay History. We'll dive deeper into this season and talk about the lasting impact of the Briggs Initiative and the continued fight over LGBTQ rights in schools. Plus, we'll share some behind-the-scenes stories and never-before-aired tape from this season. It'll be the perfect way to celebrate Pride Month this June, with LGBTQ stories and voices across generations. You won't want to miss it. Again, that's June 13th at the Tribeca Film Festival in New York City. You can get tickets now at tribecafilm.com/slowburn. Hope to see you there.
So Marches of Stern, it's June. Is the Supreme Court ready for its close-up?
It is so not ready, Mary.
Marches of Stern covers the Supreme Court for Slate.
It is hard to overstate just how not ready it is. I like to tell people that this happens every June, right? Every June, the month starts, there's a pileup of big cases, but this month is really different. They have so many crazy blockbusters, like 4 or 5 terms worth of blockbusters packed into the next 4 weeks. And I don't know how they're going to get through them, but I know that they have to because they all have vacations planned. And if there's one ironclad rule at the Supreme Court, it's that they've got to clear out by the 1st of July.
You know, I was today years old when I learned that the Supreme Court doesn't even have to make all of its decisions by the end of June. That's just like an arbitrary deadline they decided to impose on themselves.
It's completely made up, but it works for them.
So how many of these big blockbuster decisions are we about to get?
So depending on how you count, it's about 24, I would say.
And like a decade ago, it would be like half that many?
Like 5.
Whoa.
It's shocking how many there are. These are explosive cases about abortion, right? About Donald Trump, about regulations involving everything that you care about in the world, everything that makes the government function. These are cases that pose in some ways an existential threat to the government's ability to function. And they're all going to come down on top of each other. And that's going to make it really difficult for people like me to explain them because we're just going to be done explaining one when the next one is on our heads.
So today on the show, we're going to take a whack at pre-explaining what's about to go down here, as we get ready for what Mark calls Opinion Palooza. I'm Mary Harris. You're listening to What Next? Stick around. This episode is brought to you by Discover. When it comes to your finances, Discover wants you to know they are the credit card that is always there for you. With 24/7 U.S.-based live customer service, everyone has the option to talk to a real person anytime, day or night. Yep, that means no more waiting for, quote, normal business hours just to get a hold of someone. We are talking real service from real people whenever you need it. Get the customer service you deserve with Discover. Limitations apply. See terms at discover.com/creditcard. This episode is brought to you by Discover. When it comes to your finances, Discover wants you to know they are the credit card that is always there for you. With 24/7 U.S.-based live customer service, everyone has the option to talk to a real person anytime, day or night. Yep, that means no more waiting for, quote, normal business hours just to get a hold of someone. We are talking real service from real people whenever you need it. Get the customer service you deserve with Discover. Limitations apply. See terms at discover.com/creditcard. Okay, it would be impossible for us to talk about all of these cases that are about to blow our minds in the next few weeks.
Literally impossible.
Yeah. So I'm going to ask you to just talk about a couple different buckets of cases. I guess I want to start with January 6th cases because with Donald Trump just found guilty of 34 felony counts in New York City, I'm especially interested in how the highest court in the land may be impacting other cases involving Trump's behavior and future. So let's do that. First, the January 6 cases that I want to talk about. First one, Fisher v. United States. Explain what this case is about.
So Fisher is a case that would potentially undermine about 350 prosecutions of rioters who stormed the Capitol on January 6th.
And these are prosecutions in some cases that have already happened, right?
Yes, absolutely. So these are prosecutions that in at least 100 cases have already wound up with convictions. Actually, about 150, I believe, 150 rioters have convictions that rest on this one particular law that the Supreme Court is potentially going to gut.
What law?
And so it's an obstruction law that was enacted in the wake of the Enron scandal, actually. So Enron, when it was being investigated, it took a lot of steps to impede investigations into its misconduct. Congress found that there was sort of a gap in the criminal law here, so it tried to plug the gap. And it enacted this statute that targets anyone who, I'll just quote, corruptly obstructs, influences, or impedes any official proceeding, including a proceeding before the Congress.
Okay, so I can see how this applies on January 6th.
Yeah, like it's pretty obvious, I think, and federal prosecutors thought that, you know, if somebody is trying to stop the counting of electoral votes, which these rioters often by their own admission were, right? That was the whole point. They are corruptly obstructing an official proceeding before the Congress. That's the language of the law, right? But what the U.S. Supreme Court seems potentially poised to embrace is this idea that actually this is a document destruction law. And that's because the preceding sentence in the statute talks about the destruction of official documents and official papers. And so what they want to do is use that language and kind of attach it to the obstruction language and say, well, it only counts if the individuals here were destroying some kind of documents or papers or potentially evidence.
It only counts if there's a shredder involved.
It only counts if there's a shredder. And what's really bizarre, I think, and actually Justice Amy Coney Barrett brought this up at arguments and it gave me a little bit of hope. What's bizarre is that in this instance, there were official documents involved. It was the official electoral votes from the states that Congress was going to count and vote to ratify. And so the argument that I think should carry the day is even if you view this as a document destruction law, that they were there to impede the counting of these official documents. And that's no small thing, because think about the multiple indictments that we've seen in multiple states now involving electors who created fraudulent versions of these official documents, right? Like it just seems like a slam dunk. And yet, when this case went to the Supreme Court during oral arguments, you had multiple conservative justices, including Alito and Thomas and Gorsuch, basically suggesting that the federal prosecutors in these cases were maliciously targeting January 6thers because they didn't like their politics.
The outcome here matters for a few reasons. For one, some of the January 6th perpetrators are already behind bars. So if the Supreme Court rules in rioters' favor, some of those people could go free. That kind of ruling would also have implications for Donald Trump. Jack Smith has indicted Trump on 4 charges of election subversion for his actions on January 6th. But if the court guts this statute, Mark says those charges become very flimsy.
And frankly, what's left, in my view, does not stand on its own. And it's too closely connected to these charges. And so I think special counsel Jack Smith has to go back to the drawing board and further draw out this case and try to figure out other creative charges, which he shouldn't have to, in my view, because like these are very straightforward and apply to what he was trying to do. He tweeted about sending these people down to the Capitol to try to stop the count.
Trump did.
I mean, Trump's tweets were all about causing chaos and putting pressure on Mike Pence to stop the count.
So what are the odds here, in your opinion, having listened to the oral arguments?
I give it a coin toss. I don't think that a majority of the justices have a deep, empathy for the 350 regular rioter defendants who this applies to. I don't think that Barrett and Roberts, for instance, Chief Justice John Roberts, are bleeding hearts for the QAnon shaman and others. And I think that they understand that it's not just about Trump, that if they do gut this statute, a lot of those convictions, they disappear, right? They're undermined. These folks will get resentenced. A lot of them will get out of prison. A lot of them will evade prison altogether because all that's left are these very minor charges. And I don't think that they're craving that. I don't think they're in the tank for the rioters in the way that Sam Alito and Clarence Thomas seem to be. But I give it a coin toss because during arguments, even John Roberts was saying well, why haven't you used this to prosecute anybody else? And seemed to be viewing this as something sort of malicious that the Biden administration was manipulating. And that is very disturbing.
Okay, let's switch gears because this is not the only January 6th case. We also have Trump v. United States, which is all about presidential immunity and whether Donald Trump has immunity for crimes committed while in office. And really, it kind of gets into whether all presidents have immunity, right?
Yeah, this gets into the question of whether the president is above the law. I mean, that's the simplest way to put it and in some ways the most accurate. The question here is whether Donald Trump can be immunized from Jack Smith's criminal prosecution for acts that he took while in office.
Simply because he was there.
Simply because he was there, and he calls these official acts or within the outer perimeter of official acts. But, according to him, that could include things like weaponizing his own office to try to interfere with the Department of Justice and pressure states to throw out valid votes and overturn the results of the election.
Yeah, Trump's attorney kept getting asked, could you guys assassinate a political rival with SEAL Team 6? And is that an official act? And
yeah,
they kept saying yeah.
Yeah, they kept saying yes, basically. And their theory is that a president is immunized against criminal prosecution unless he is impeached and convicted in the Senate. And after he's convicted, then and only then can he be criminally prosecuted. And this only emerged as a theory after Donald Trump was trying to fight these indictments.
Yeah, I was going to say, this argument really sticks in my craw. Because back in January of 2021, the whole argument was, let's not impeach this guy because the courts will deal with it. And let's, he's out of office anyway, nothing to pay attention to here. And this basically says, well, you only could have convicted him in a court if you impeached him first.
So Trump's own lawyers made that argument. Mitch McConnell made that argument. A number of Republican senators who voted to acquit Trump made that argument. It was not on anyone's radar that Trump's lawyers would later concoct this fabulous theory for him that, he could actually only be convicted in a court of law if he were convicted first in the Senate. And yet, when this case got to the Supreme Court, and I was in the courtroom for arguments and I nearly fell out of my chair because I was so stunned by this, it sounds like it will be a very close call whether the Supreme Court embraces either that argument or maybe some lesser but still very dangerous argument.
In February, you and our other colleague, Dahlia Lithwick, made the case that the Supreme Court never should have taken up this immunity case. Why did you guys make that argument? Why do you think so?
Because the U.S. Court of Appeals for the District of Columbia Circuit came to an incredibly strong and I think rock-ribbed conclusion that none of Trump's frivolous arguments were based in law. And the decision in that case was written by a conservative appointed by George H.W. Bush. I mean, she's certainly no bleeding heart, but she made the really robust case that everything Trump was arguing was garbage, that none of this is based in the Constitution. Maybe it's good policy to insulate presidents from prosecution. Maybe it's good policy to give them some kind of wide berth from accountability if they commit crimes in office. Maybe, maybe not. But either way, the Constitution has nothing to say about it. And we both thought, like, the Supreme Court should just say, yes, that's correct. They could have done so in a one-sentence order. They could have summarily affirmed it. And instead, what they did was take up the case, draw it out, add a day of arguments at the end, and now they're not going to hand down an opinion probably until the end of June, which means, practically speaking, that even if they give a whole victory to the Biden Department of Justice, even if they rule against Trump in toto, this case still will not be heard before November, and that means if Trump wins, he can make it go away.
We'll be right back.
McDonald's presents Burger Reviews by Hamburglar. Today's review, the hotter, juicier classic burgers. Mr. Hamburglar. Rubble, rubble. He said, of all the McDonald's burgers I've ever hamburgled, these are the hottest, juiciest, and tastiest. Rubble.
Hamburglery is on the rise. Get caught with a medium double cheeseburger meal for $6. Price and participation may vary. Promotion pricing may be lower than meal price. Comparison to prior classic burgers.
Ba-da-ba-ba-ba.
Here is just a quick spin through a few of the Supreme Court cases that we're about to get decisions on. There's a case about whether the abortion pill is truly legal, a case about whether ER doctors have to terminate pregnancies if they put a woman's health at risk. There is a case about whether social media companies can limit certain kinds of speech on their platforms, a case about laws that criminalize homelessness.
I mean, you take your pick, but I think personally the next category of cases that we have to talk about before we go are the gun cases.
Yeah. Talk to me about what we're about to hear, because there are a couple of these gun cases. One of them is Rahimi v. the United States, which looks at the rights of domestic abusers to have access to firearms. Then there's Garland v. Cargill, which is going to decide whether or not the federal government can ban something called a bump stock. Let's talk about Rahimi first.
So Rahimi involves yet another crazy decision from the Fifth Circuit. So the Fifth Circuit ruled that a person who has been adjudicated to be a domestic abuser in civil court, who has been placed under a restraining order for domestic violence against an intimate partner, that person still has a Second Amendment right to bear arms, and purported to strike down a federal law that bans domestic abusers from possessing firearms.
And we should just be really, really specific about who this guy we're talking about is. Zaki Rahimi, he had a protective order against him from an ex-girlfriend. He was doing stuff like firing shots into the air at a Whataburger after his credit card was declined, shooting at drivers on the highway,
committing robberies, beating his girlfriend.
So the argument is that guy has a right to guns.
Correct. This was a bad dude who has been convicted of really violent offenses and found guilty of being, a violent criminal, who is arguing that he has a Second Amendment right to bear arms, which the Fifth Circuit agreed with, which I just think is shocking because all of the data shows that domestic abusers are so much more likely to kill their intimate partners with guns, to commit mass shootings with guns, to, do very bad things with their weapons. And at the same time, I sort of can't fault the Fifth Circuit because I think that it correctly applied the Supreme Court's most recent Second Amendment test.
Which basically says, the original intent in the Constitution is, y'all can have guns. Everyone can have guns.
Everyone. So the Supreme Court has said if there is not an analogous law, or actually a bunch of analogous laws from some time period between 1791 and 1868, they're very hazy about the dates. We don't know, but there have to be a bunch of analogous laws from that earlier time period that align with the modern gun restriction. And if there aren't, then the modern gun restriction is unconstitutional. It doesn't fit with the history and tradition of our country. The problem is that domestic abuse was not a crime for most of the history of our country, certainly not in that time period. And so the Fifth Circuit sort of pointed to that and said, look, women aren't people, or at least they weren't back then. So there's nothing we can do. We have to let their intimate partners have guns.
Notably, Zaki Rahimi, the guy who's the major part of this case, he said he doesn't even want to own guns anymore.
Isn't it amazing what can happen when a case is freed from the very tight publicity strictures of like an advocacy group and goes out into the wild? It's just incredible what's happened with this case. And one of the things that's happened is that it reached the Supreme Court, and the Supreme Court was aghast. Again, Amy Coney Barrett was like, seriously, guys? Seriously? Are we really saying that this guy has a right to bear arms? And yet, I think that Amy Coney Barrett should look in the mirror, because she joined the Clarence Thomas opinion 2 years ago that established this test that if there wasn't an analogous law like hundreds of years ago, then you don't get to pass the gun restriction today.
Where do you think they're going to come down on this?
They're going to reverse the Fifth Circuit. Okay, they're going to reverse the Fifth Circuit. They're going to say that this law is constitutional.
They're going to live in their contradictions.
They're going to make something up. You know, the magic of being a Supreme Court justice is that you get to just make stuff up as you go along. You set a test, you decide you don't like it, down the road you tweak it, you change it. So they're going to do something to get themselves out of this mess. But whatever it is, it's not really going to be faithful to their own precedent, and it's not really going to be originalism. It's going to be some kind of bizarro, like, oops, we can't follow our principle to its logical endpoint kind of concession that carves out some kind of exception here, while I think leaving the larger law of the Second Amendment in a state of absolute chaos.
Okay. There's also a case about bump stocks, whether actually we can ban them, which is something the Trump administration tried to do. Can you describe what's going on here?
Yeah, and would you believe it's the Fifth Circuit that struck down the ban on bump stocks?
Shocking.
Yeah, the Trump administration banned them after the Las Vegas attack, which used bump stocks to kill more than 50 people. And I think had really strong grounds to do so, because the federal statute here, it bans machine guns, but it also bans parts that can be assembled to create automatic firing.
And a bump stock enables you to shoot much faster, right?
Exactly. And would you believe, Mary, that Amy Coney Barrett holds this case in her hands? She was really active during oral arguments. I heard, I wasn't in the courtroom for this one. I heard that they were like making like guns with their fingers and trying to like demonstrate how this worked. Like, she was like, I watched the videos of how this works. Like, I think I understand it. And it sounds like it's automatic. And yet I don't know how it's going to come out. It's another coin toss case, because at the same time, some of the other justices like Brett Kavanaugh were like, well, but you're going to criminalize law-abiding gun owners who just love to shoot bump fire for sport. You know, this one is going to be another 5-4 decision, or maybe 6-3, but it's going to be close one way or the other.
It's interesting to me that this case would possibly dismantle a gun regulation put in place by Trump. Like, what does that tell you about how this conservative court is operating?
It shows you how extreme they are. I think it just shows that even a very sensible regulation that was responding to a sort of emerging concern that seemingly Congress had already accommodated for in this capacious language, that even that is maybe too much for a Supreme Court that is fixated on this idea of a Second Amendment right that's basically unlimited. And I mean, we could go into why that whole conception is ridiculous. It's ahistorical. It's not what the Second Amendment meant. It's not what the framers intended it to mean. But, you know, they just have this deep concern for the rights of gun owners, including the rights of, people who want to shoot AR-15s at a rate of 100 rounds per minute. And that's a concern that doesn't apply when you're talking about women who need emergency abortions, or women who want to terminate early in pregnancy, or homeless people who are being criminalized for being homeless, or, we could go down the list, right? They don't care about those victims or those people. But when you're talking about some rando in Montana who's like desperate to keep bump firing because he just loves guns, then the Supreme Court is at close attention and like is deeply worried about his rights.
Okay, before we go, I don't think we can avoid talking about the personalities on the court. And I say that because we keep talking about a few distinct justices here. And of course, because I feel like Sam Alito is just putting himself out there recently. I mean, I think my listeners will be familiar with the fact that there was reporting in the New York Times that he was flying various January 6th associated flags at both his home in Virginia and his home in New Jersey. I don't get the sense you're surprised that Sam Alito is letting his freak flag fly here. But how should we think about that? Because Justice Alito is one of the people who's set to decide, as we've talked about, what happens with January 6th rioters, what happens with Donald Trump. And it seems like he or his family or his flagpole know how they feel here.
I feel like I am not sure, as a Supreme Court analyst, how I am supposed to tell people that these are legitimate decisions by a court with any kind of authority and like legitimacy itself, when somebody like Alito is out there flying these insurrectionist flags, or somebody like Clarence Thomas is married to a Stop the Steal enthusiast. I don't know how the American people could be expected to accept these decisions as the valid law of the land when anyone who's paid attention to the news knows that part of the court is frankly corrupted. And I think that poses like a huge problem, not only for me as someone who's trying to translate this stuff for a general audience, but quite obviously for the Supreme Court itself. And I hope, this is my one moment of optimism, Mary, I hope that what this corruption on the far right flank of the court does is push John Roberts and Amy Coney Barrett, and to a lesser extent Brett Kavanaugh, a little bit closer to the center.
Just because they have to like make up for it?
They have to make up for it. They are very conservative justices. They are historically conservative. Some of the most conservative who've ever sat on the court, right? But they care about the court's institutional integrity. And so my deep hope is that, especially in a case like the January 6th stuff, that they will see colleagues like Alito and Thomas letting their freak flag fly, so to speak, and it will push them a little bit more toward the center and push them to try to recover some of the court's integrity by doing the right thing.
You know, one thing I couldn't help but notice as we talked is one name keeps coming up again and again: Amy Coney Barrett. And I know that other people have said, by the end of this month, we may be calling this Amy Coney Barrett's court, not the Roberts court. Why?
Because it stopped being the Roberts court really the day that Justice Ginsburg died. And Amy Coney Barrett increasingly occupies the center seat, which I want to be clear is not a moderate seat. It doesn't make her a centrist. It means that she is increasingly the median vote on the court. And that's partly because Brett Kavanaugh, who formerly occupied that seat, has been drifting to the right. And I also think that she is deeply put off by the kind of disobedience and radicalism on the lower courts, specifically the Fifth Circuit. And she doesn't want to be the justice who facilitated the end of the rule of law and the end of the judiciary's legitimacy. And so she's trying to spin a lot of plates at the same time, and she's not always succeeding. But I get a stronger sense from her than from somebody like Brett Kavanaugh that she's trying to do the real work of judging rather than just acting like a philosopher king in robes who's imposing whatever policies he happens to like and stamping it with the label of law.
Mark Joseph Stern, always a pleasure to have you on the show. Thanks for coming on.
Thanks so much, Mary.
Mark Joseph Stern is a Slate senior writer covering courts and the law. All this month, he is going to be covering the court's biggest opinions over on Amicus. That is our Supreme Court podcast. You can hear Amicus on your podcatcher of choice. Check out all our opinion coverage at slate.com/opinionpalooza. All right, that's our show. If you're a fan of what we're doing here at What Next, the best way to support our work is to join Slate Plus, going over to slate.com/whatnextplus to sign up. What Next is produced by Paige Osburn, Elena Schwartz, Rob Gunther, Anna Phillips, and Madeline Ducharme. We are led by Alicia Montgomery with a little boost from Susan Matthews. Ben Richmond is the Senior Director of Podcast Operations here at Slate. And I'm Mary Harris. Thanks for listening. I'll catch you back here next time.